You're welcome. In a recent whirlwind of legal battles, the Court of Appeal has upended the political landscape in Plateau State, sacking Governor Caleb Mutfwang and affirming Nentawe Goshwe of the All Progressives Congress as a valid winner of a March 18 governorship election in that state. Now, this ruling follows a series of similar judgments affecting the opposition governors across different states in Nigeria. I'm talking Zamfara State, I'm talking Kano State as well. Tonight on Politics HQ, we attempt to unpack the issues surrounding this particular development and the implications of these court decisions. From the legal intricacies to the potential impact on Nigeria's democracy, let's explore the intersections of law and politics in these contentious judgments. Our guest tonight on the program, we expect to have Musa Ashoms, who is the Commissioner for Information in Plateau State. But we do have right now Emmanuel Madaki. Madaki is a legal practitioner. Emmanuel, very good evening to you, and thank you very much for your time. Emmanuel, are you there, please? All right, we now have the Commissioner for Information, Plateau State, and of course he is with us live to look at this issue. Mr. Musa Ashoms, a very good evening to you.
And thank you for having me this evening.
What is your reaction, and by extension that of the Plateau State Governor, Caleb Mutfwang, to yesterday's court judgment regarding his position?
My reaction is not different from that of Plateau citizens. It came to us with a rude shock because the people had given Barrister Caleb Mutfwang their mandate. They all went to their polling units, and at the end of the day, we got victory. But you know how Nigeria operates. When people lose, they become sore losers. They look for different means to snatch the mandate that was freely given by the people. And from the polling units, we got victory. At the tribunal, we got victory. But we got a temporary setback from the Court of Appeal. But glory to God that that is not the end of this matter. It can be pursued up to the Supreme Court level. And our lawyers have been mobilized to do so. And by the grace of God, we're going to come out successful. We're going to come out victorious. If you check the mood on the Plateau, when people get declared as winners, Plateau will go agog. But if you ask your reporters and other reporters, it's like there's a graveyard environment, a graveyard situation. The ambience doesn't look good. People are sad. People are disappointed. People feel that their mandate has been raped. But like I said, there's a room for remedy. There's a room for remedy. There are remedial moves that can be made, and we have made all of that. Very soon, we'll approach the Supreme Court, and the people's mandate will be restored to them, just like we're trying to restore Plateau State to the days of glory. His Excellency Barrister Caleb Mutfwang is not perturbed by this judgment. He has been a legal practitioner for over 3 decades, so he understands how the court operates. So it's not something that should give us worry. We have tried to calm our people. We have tried to make them understand that it's just a process, and different courts have their interpretations of a particular matter. And the Supreme Court of the Federal Republic of Nigeria has ruled on this kind of matters, on similar matters. And we know that it's going to be positive from our own end. We know that the people's mandate will be restored.
Okay.
And at the end of the, we'll fall back to good governance like we have always been doing from day one.
All right. Interesting, Mr. Commissioner, considering the reasoning behind the judgments, what legal grounds were instrumental to the removal or in the removal of Governor Mutfwang, you know, and affirmation of his opponent, Nentawe Goshwe of the APC as the new governor?
If you followed the judgment closely, you will see where they were talking about structure. You will see where they were talking about our party, that there was no PDP in the first place. So therefore, his nomination is null and void. And for those of us that understand democracy, if you check the event, the transition that got us to winning the primary election, to secondary election, and by the grace of God at the tribunal, you know that the PDP is a well-structured political party. It is disheartening that somebody will wake up from his slumber, deep sleep at that, to say that there's no structure in the PDP on the plateau. If you recall, in 1998 to 1999, when the PDP started, the maiden chairman is from Plateau State. Plateau State is a state that you have people that are politically intelligent, people that are politically exposed, people that are politically experienced. So for you to come and say we do not have a structure is suicidal. It doesn't make any sense. It's the highest display of naivety. And again, we cannot, if we don't have a structure, we are not complaining. So meddlesome interlopers, people who do not have any business with our political party, shouldn't be talking about our structure. We're not complaining. And INEC monitored our congresses on the plateau. The security operatives were there as witnesses to forestall insecurity, in case there's insecurity, for them to make sure that everything goes out well. We had to do congresses over and over again so that issues will be fixed. Like when General Senator Tunde Ogbeha was sent by the party, the national PDP, from the national headquarters to come to Jos and become caretaker committee chairman. Barrister Ndayako from Niger State was the legal advisor. Chief Ogbu from Benue was secretary. And we had 8 other Plateau people in that team, making up 11 for caretaker committee. 4 from the Senator Jeti Hussaini side, 4 from the Senator Donna David Jang side, to make up 11-man committee. And this 11-man committee were the ones that conducted the state congresses in Plateau State. And all the local government in Plateau State participated. There were litigations, but we overcame them. Even when the court ordered us to go for another Congress, we did it. So surprisingly, what we did in 2021, they are bringing it in 2023.
All right.
And it is just a clear case of meddlesome interloper. Or if you have any word that can replace it, we can call them political bandits or thieves or people that have squandered.
All right, Mr. Commissioner, we'll come back to you.
Embezzle the opportunity that the people have given us.
Yes, we'll come back to you. You used some interesting description there, but we have a lawyer, Emmanuel Madaki, with us. Emmanuel, what are your thoughts on the legal grounds that were instrumental to removal of Caleb Mutfwang as governor of Plateau State? Some of the things that have been highlighted by our guest commissioner for information for Plateau State, indeed, is what the Court of Appeal judges said. For instance, saying that the People's Democratic Party in Plateau State lacked a political structure and therefore was incapable of validly nominating or sponsoring any candidate for the governorship, or therefore all the votes cast in favor of Caleb Mutfwang amounted to a waste, according to the judges of the Court of Appeal. And they're citing, Goshwe, through his lawyers, in his final brief, cited Section 177C of the 1999 Code. I just want your thoughts on all of this. Emmanuel.
This ample opportunity given to me to express my deep thoughts on the judgment of Plateau State election and in respect of the appeals, especially the gubernatorial appeal that was delivered yesterday. To me, as a person, I did not see it as a surprise, because it is the same Court of Appeal panel that nullified the election of the Senate Minority Leader and ordered for a rerun, and also nullified other National Assemblies elections in the state. And that's notwithstanding the fact that that has been done. We actually saw this coming because the same panel of justices had actually taken a position. And despite protestations by the PDP in Plateau State, that of course they had lost confidence in the panel of justices, they refused and they continued, despite the fact that there were a lot of allegations that were raised. Now, coming to the constitutional provision that talks about the qualification of a candidate, if you check Section 177C or Section 177 simpliciter of the 1999 Constitution as amended, it has clearly stated that there are 4 practical grounds upon which an election can be questioned or a candidate can qualify to stand for an election. One, you talk about that the person must be a citizen of Nigeria by birth. Two, that the person must have attained the age to stand for that election. Three, that the person, that is C, the person must be a member of a political party and he must have been sponsored by that political party. And number five, it talks about the fact that the person has schooled, has attended or attained the educational requirement as contemplated by the Constitution. It was not shown anywhere that Caleb Mutfwang, the governor of Plateau State, did not meet all those basic requirements. And going to the disqualification of a candidate for election, that can only be found under Section 182 of the Constitution. That all those requirements there, nobody was able to prove in court that the governor provisions of the law. And what is even more, the petition of the APC was preponderantly anchored on an alleged disobedience of a court order. The greatest despondency at the tribunal, PDP was able to establish, beyond any cognitive thought, that indeed PDP is strong, formidable, and has a solid structure in Plateau State, and the issue of disobedience of court order had not even arisen, and it has not even cannot even ground a relief for the nullification of an election. We cited cases wherein the Supreme Court had caused to say disobedience to court order is not one of the grounds upon which an election can be presented. And PDP, before the 2023 general election, a member of the PDP approached the Federal High Court, a person of Augustine Tinko. And in that suit, he sought for the nullification or for the disbandment of all PDP candidates that INEC should recognize them. The Federal High Court decided that case, and the issue of lack of structure came to the Court of Appeal, to the Federal High Court. The Federal High Court, in its wisdom, said that PDP complied with the court order since 2021, on the 25th September 2021. That decision was appealed against. That finding was appealed against to the Court of Appeal, Just Judicial Division, and the Judicial Division of the Court of Appeal affirmed that decision, that PDP has complied with the court order. That is the most recent decision in respect of whether or not PDP has complied. That decision was delivered on the 11th day of February 2023, the Court of Appeal decision. But lo and behold, this time around, the Court of Appeal is now turning out contradictory decisions, overruling the Court of Appeal over a subsisting decision. And of course, Augustine Tinko is alive. He has a right of appeal because in that appeal, he claimed that he was not given fair hearing. But the Court of Appeal in its finding said that he was accorded fair hearing. PDP is not in disobedience of any court order. What is even more, Section 134, 1A of the Electoral Act, it is a provision upon which the petition is anchored. APC did not approach the tribunal to say that they won election. APC did not approach the tribunal to say that the election was
Emmanuel,
by irregularities.
Emmanuel,
APC did not approach the tribunal to say that.
Yeah, Emmanuel, I want to bring in the commissioner at this point. Thank you so much. I'm sorry to interject, with your flow of thought there. But Mr. Commissioner, Emmanuel has talked about a court case. Some people would argue, and I've spoken to some lawyers who say the issue is not about whether, the governor won the election or not, but that the judges or justices of the Court of Appeal were quite clear, just as it was in the case of the senator and House of Reps members who were also removed some days ago, November 7, which sacked 3 House of Representatives members from Plateau State and the senator, that even though they won their respective, they held that even though they won their respective elections, but because of this court order made in 2022 that directed the PDP in Plateau State to conduct another Congress or Congresses in 17 local government areas, they're saying that they did not conduct these congresses in about 12 or so of these local government areas. And therefore, the procedure that produced the candidates of the party, now including Caleb Mutfwang, was not legal, was in disobedience of that court order. And that's why they've been able to, referring to a court order, say his votes at the election are wasted votes. So how about that, Mr. Commissioner?
Let's set the record straight. The court order was not in 2022. The court order was in 2021. And after the court order, the PDP had its congresses on the Plateau in Langfield, the South local government area of Plateau State, where all the 17 local government areas participated. So they shouldn't be misinforming the general public. The court order came that we should go ahead and have congresses. Justice Kunda nullified our congresses. Justice P.S. Gang said we ordered for for another congress, and we had that congress. I have the correspondence from the national headquarters of the PDP, where they said the Senator Tunde Ogbeha-led caretaker committee should hold a congress, and the party wrote to INEC and gave INEC 21 days notice, and INEC came and monitored the election, the congresses, and in the 2023 general election, INEC fielded PDP as a party in the election, and the Plateau people made their choices. They went for Barrister Caleb Mutfwang, they went for PDP, they went for these senators and House of Reps members. It's quite unfortunate that their litigation ends at the appellate court. But in our own case, we have to go to the Supreme Court, where we have classical examples of cases like that. For example, Ugo Ugochinyere from Imo State, they disqualified him that his nomination was faulty. The Court of Appeal said this is not a tribunal issue, it is a pre-election issue. In pre-election, when you do not participate in the primary election, you cannot even take the party to court. All those that contested the governorship of Plateau State are facing their different businesses. They are doing their different businesses. If you go to Plateau, go get the clips. The APC primaries was marked by irregularities. People staged a walkout, but we didn't say anything because it's not our party. That is how they do their things. If you go during their congresses, Ishaya Ite and Barrister Joshua Madaki were the ones that purchased forms to become party chairman. But the former governor decided that one Rufus Bature should be chairman. We didn't say anything because that is not our political party. Our modus operandi is different from theirs. But for you not to win an election, for you to go to court, you squandered the opportunity for you to lead Plateau State. You remember this APC were in government for 8 years in Plateau State. Plateau State people have a way of making their decisions. The court cannot change it. When Plateau people go this way, allow them to go that way. That is the beauty of democracy. They had options, but they went for the best option. So the courts cannot change it. I am not trying to indict the courts. Every court has a way of interpreting its matter. In our own case, we bless God that there is a Supreme Court somewhere that will handle the matter. And the Supreme Court of the Federal Republic of Nigeria, that is why it is there. So that if there are anomalies, if there are judgments that you're not comfortable with, you can approach them. And that is what we have done. We're not going against the law in any way. We are law-abiding citizens. Our governor is a barrister and solicitor of the Federal Republic, of the Supreme Court of the Federal Republic of Nigeria. He's a gentleman by instinct. He is called to be governor. So I think the enemies of democracy should keep quiet and allow Plateau people to enjoy the dividends of democracy. They have kept us behind for a while, and the people have made their choice. Their choices should count.
Thank you very much, Musa Ashoms. Emmanuel Madaki, I just want you to just give some more, of your views on the judgment and aspects of it. The issue of qualification, as captured in Section 177, subsection C, or 177C, rather, of the Constitution of the Federal Republic of Nigeria. And also, we can look at the Electoral Act and look at Section 134C. In your opinion, is this both a pre-election and post-election matter? Because contrary to the findings of the tribunal, which earlier framed the election of Governor Mutfwang, this Court of Appeal is saying that it is both a pre- and post-election matter.
Thank you very much. I think it is quite important to understand the gamut of our electoral jurisprudence, which of course has compartmentalized the various places one should go to ventilate his grievances. And that is why the Electoral Act 2022 has come with an innovation. And the innovation is very simple, that issues, anything that predates or precedes the conduct of election is a pre-election matter. It cannot see itself at the tribunal. The tribunals, which of course it is a decision of the tribunal that are being reviewed at the Court of Appeal. The tribunal has a limited scope, and that scope is as defined under Section 285, sub 2 of the Constitution. It is a constitutional requirement that the tribunals are mandated to look at events arising from the conduct of election and not events that happen before the conduct of election. The only ground that can see itself at the pre-election and post-election stage that actually may mean a qualification is where you are talking about where a candidate, falsifies his information under from TF001.
Yeah, but Emmanuel, qualification is qualification. And that's what I'm asking you, when it comes to qualification, I mean, generally speaking, is it both a pre and post-election matter? Because you've said it. You've said it yourself.
And that is why,
you've said it yourself, Emmanuel, that, I mean, for instance, we look at academic qualification.
No, listen, that is why I am trying to clarify the points for you. Qualification can be a pre and post-election matter, but then it is distinguishable. What is the type of qualification that can be both pre-election and post-election? That is what I'm trying to.
Yeah, but Emmanuel, you read it yourself. Section 177C talks about qualification for the election. Now, we've seen the precedent of cases, especially in 2023, where the courts have refused, both the PEPC, for instance, presidential election, and the Supreme Court refusing to dabble into internal party affairs, and also questioning the local standing of the appellants to bring such matters. Yeah, but what I'm just driving to the point is that isn't this particular issue of qualification of Governor Caleb Mutfwang an issue that is different from the result, how the party primary was conducted, who conducted it, whether he was cheated or not, because it's talking about his nomination and it's talking about his sponsorship, that the party did not.
Now, I can assist you with plethora of judicial decisions by the Apex Court that have clarified this issue. The question of nomination and sponsorship of a candidate, no matter how colored or how under which guise the person brings it, it is a pre-election matter. I wanted you to understand the point that the only thing that can become a pre and post-election matter, it is where the person lies or falsifies his information under Form EC9, which is the affidavit and particulars of the candidate, and that is not the position here. The question of the decision that we are now talking about is a purely pre-election matter, and it is only an aspirant who participated in the primaries of the PDP that can challenge it. They have now disguised it to bring an alleged disobedience of court order to be the question of qualification. By the special grace of God, there are authorities by the Supreme Court, wherein the Supreme Court has had cause to say disobedience to court order cannot be a ground to challenging an election. The election tribunal is not a place to enforce court judgment. And despite the fact that the PDP was able to present cogent and verifiable evidence to the effect that PDP complied with the court order, and it cannot be a post-election matter. It is purely a pre-election matter. When did this happen? The question of compliance happened way back 2021. Why should you wait? That is why the new Electoral Act has made it compulsory that for you to disqualify a candidate under Section 134 to present a petition, no candidate shall be disqualified unless and until you bring it also and pin it under Section 134 subsection 3 of the Electoral Act that says that you must pin it back to the constitutional requirement. Now they are bringing it under Section 177C to say that he was not a member, that PDP did not sponsor him. But in their own petition, they have said that PDP, Caleb Mutfwang was sponsored by PDP. They contradicted themselves in their petition. Now, let me even tell you, if you read that judgment, the court itself, the Court of Appeal, departed from the case that the petitioners and the appellants presented. The appellant presented a case of nomination and sponsorship. And we are saying nomination and sponsorship can never come to the tribunal, can never come to the Court of Appeal for review. Why? Because the petitioners, now appellants, do not have the locus standi to even ventilate that grievance.
All right. All right. Section 134. Section 134. Yes. So Emmanuel, thank you. Section 134. Emmanuel, thank you. Thank you, Emmanuel. I'm just going to read Section 134, sub 1 of the Electoral Act. It says an election may be questioned on any of the following grounds. Talking about grounds for petition. A, if the person whose election is questioned was at the time of the election not qualified to contest the election, at the time not qualified. And Section 177 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, talks about qualification. So if the Electoral Act is saying that this is a ground for petition, that you were not qualified at the time of the election, and they're relying on one of the provisions or qualifications as enshrined in the Constitution, 177C, which is sponsorship by the party, then one would think that it is a ground for petition. But you've given us your thoughts. We have, let's look at quickly the states that have had the governorship, election decided by the Court of Appeal. You can see, Kano State, party in power was the NNPP, the appealing party APC. Judgment was in favor of the APC. Nasarawa State, APC, party in power, appealing party PDP, judgment in favor of the PDP. All right. Zamfara State, you have party in power PDP, appealing party APC, judgment in favor of APC. So it's 2-1. I think now with Plateau State is, okay. So you have in Plateau State, PDP in power, APC appealing, judgment in favor of the APC. Lagos State, APC in power, PDP LP appealing, judgment in favor of APC. And now we had Benue State, APC in power, PDP appealing, judgment in favor of the APC. And of course, we now have Bauchi, PDP in power, appealing party APC, judgment in favor of the PDP. Enugu State, PDP in power, LP appealing, judgment in favor of the PDP. Quite interesting stuff right there. Final words from you, Mr. Commissioner. I'll take you first before I go back to Emmanuel. Emmanuel, I hit one there. I want to respond to that. Musa, Ashoms, very quickly, in a sentence, please.
We want to thank Plateau State people for giving us this mandate. And, His Excellency Barrister Caleb Mutfwang is not going to betray your trust. All right. We hope that after the Supreme Court must have given us our mandate back, we'll continue with what we've started. This is just what is temporary setback. And the governor is poised at giving Plateau people purposeful leadership. We're here to reset the foundation of Plateau State. Little wonder the 2024 budget is christened budget of new beginning.
Okay, thank you very much. Thank you very much, Musa Ashoms. And of course, Emmanuel, a very brief final word from you. Very brief.
The decision of the Court of Appeal, was perverse. It was bereft of substance, and it was bereft of the law. That judgment had no connection with the law. It was pure sentiment. But I want to believe, and I'm sure, the Supreme Court has set precedent. And I want to assure you that this precedent will be sustained.
Thank you.
Because the Supreme Court is a policy court.
Thank you very much. Thank you very much for your time, Emmanuel Madaki, legal practitioner, and Musa Ashoms, Commissioner for Information, Plateau State. Of course, Governor Caleb Mutfwang has headed to the Supreme Court. We'll keep our eyes on that story.